I had 6, 7 heads. This is my second head.
Education.
And it starts, fellows, this head starts at resignation.
The act of resignation.
The act of resignation subsequently on 29 June would not defeat and would have no relevance to the reversal of the illegal action of the governor of 28/6. And in accordance with precedent, this honorable court should effectuate a real and meaningful remedy. Now, as the Lordship recollects my A3 submissions, para A to N, which are repeated here, I argued ibi jus, ibi remedium, fait accompli, status quo ante, all that. I'm finishing off in one para. I'm not arguing. I'm just reminding your Lordships. Now, skip all that and come to para 14 for a minute. Does my Lord have para 14? Once the illegal act of the governor is allowed to be implemented, the result was a known and foregone conclusion. Factually, there was no need for the ex-CM to subject himself to it. The most important thing is it's a prior challenge. The illegal act of the governor is a prior pending sub judice challenge before the trust vote.
So you are really saying that Mr. Uddhav Thackeray resigned only because he was called upon by the governor to face a trust vote?
I'm grateful. After I had filed a petition, after I had made it sub judice, and after I had said this is completely unknown to law, don't allow it to go on.
And you are frankly accepting the fact that, well, you resigned because the trust vote was going to go against.
When you do an illegal act,
yeah,
the consequence of that is known to me. Now, just to save time, let me read it. The crux of the issue raised in the petition, where Lordship has got 14A, Malas, 14A, third line. The crux of the issue raised by the petitioner remains that the direction to hold the trust vote was an illegal act because the governor did so by recognizing a faction of 34 legislators. The CM's participation or absence of participation would not dilute that fundamental illegality. If it is illegal, it's illegal. How does my non-participation validate the act of the governor? Is the core question. That's the correct legal answer. In law, since the illegality of 28 was already sub judice, so prior is important, and pending in a court, a participation or absence of participation ex-CM could not possibly affect the prior illegality, which is already sub judice. Now, as an example, if one, this is very important, if one were to assume that I had subjected myself to the trust vote, the ex-CM had subjected himself on 30th and lost, and after losing challenged the trust vote, it would make no difference in law because the trust vote was merely the consequence of the illegal act of the governor. And the challenge would still relate to the governor's actions and not to the trust vote. D. It is therefore obvious in law, Malas, that the consequence of an illegal act, emphasis on consequence, cannot determine the legality of that act or validate it. Indeed, it could also be said that the petitioners, having challenged the core illegality at the base, namely the governor's actions, without any delay, did not even need to challenge the trust vote. I could have said it's nothing but a consequence. Similarly, if the individual illegal actions are broken up, and there are different petitions, it is clear that for the purpose of legal validity, either the first act of the governor in calling for a protest or the subsequent act of the governor inviting an administrating oath, the participation or absence of the ex-CM has no relevance. Now let's just go back up. Let's kindly scroll up on this section. Come to para 3. No, I'm sorry. Para Malas.
So this is the second point. No, Dr.
This is the second point, but just one thing is left here, Malas. Para 9. Para 9. I'm not troubling with A3. My submissions A to N are giving the law ibi jus, meaningful, status quo ante, scrambled egg, fait accompli. All that is given with law, Malas. In that, kindly, Malas, do me the favor of treating it as having stated here. Now, Malas, number 10. Indeed, in Bomai, paras, etc. given, the overwhelming majority of 9 judges made it clear that the proclamation under President's rule under 356, there were 2 states involved, Malas, Karnataka and Meghalaya, is very important, is liable to be struck down and the dismissed government is fully entitled to be restored to office. But the only reason we are not doing it because elections have happened in the intervening period. Now just this is very important. This has not been shown to your Lordship. Just give me a minute. 398 and 5 judges out of 9 say this. 5. First is Justice Jeevan Reddy with Justice Agarwal. The proclamation must therefore be held to be not warranted by Article 356 outside its purview. Cannot be said that the President was satisfied that the government of the state cannot be carried on. The action was mala fide and unconstitutional. The proclamation is accordingly liable to be struck down. And we would have struck it down, but for the fact that elections have since been held and a new assembly has come in. That's the only exception. Today the illegal government is running. There is no elections. Then, and the person who otherwise, suppose the Lordship holds the governor to be bad, then a person not entitled to be holding the post of Chief Minister. How can, of all courts, the Supreme Court accept such illegality? Malas, if your lordships, malas, your lordship's powers are unique in this country, in that even your lordship's malas can go beyond the law. Not contrary to law, beyond the law. Then malas, what's the point if the governor's actions are held to be illegal? Actually, your lordships would be malas, giving a Pyrrhic declaration and accepting that the illegality has borne the fruits of its illegality and people have enjoyed it. Now let's just see next one. In state of Meghalaya, it's very interesting, malas, for the other state in Bombay, para 12 of my note. Again, malas, Justice Reddy said, but for the fact that since the proclamation, fresh elections have been held to the assembly. So suppose Meghalaya had not had elections and Karnataka had, they would have restored Meghalaya. They would have certainly issued the writ and directed restoration. Justice Sawant for himself and Justice Kuldeep Singh, our conclusions may be summarized. However, in view of the fact that fresh elections have been taken place and new assemblies have been constituted, all no relief is granted consequent upon the declaration. Therefore, malas, this is the heart of this point. Now come to malas, page 1. On 189. The third point is 189.
What is the point, Dr. Singhvi?
Yes. Now, well, a very strange argument was raised, de facto doctrine. Regularization and validation by 189. Mr. Salve argued at length. Mr. Mehta also argued, I
Page
believe.
189, I'm sorry to interrupt. What is 189?
No, page 1.
Page 1 of my note. That is one of the de facto doctrine that actions validated by the actual act which is challenged is illegal. I want to show Manoj how wrong this can be and how dangerous it is. Give me just 2 minutes. The case law makes it clear, but just come to the case law later. Just give me 2 minutes. Manoj, the first important thing is to note that, Manoj, there are two kinds of challenges. One is a challenge to the very validity of the act. Come to para 8 Manoj of my note. So I challenge Manoj a validity of an act. Let us say the Governor's Act. Let me say competence of a legislation. Let me say fundamental rights. Versus the eligibility of certain people to act under the act, to sit there and act. Your Lordship under 189 protects the second, not the first. If the Governor's action is bad, will 189 ever protect it, Manoj? Mr. Manoj, friends, two of them argued at great length on 189. Did they answer the question? Ultimately, the core question, my lord, is just formulated either way, this way or that way. Is the governor valid or not valid? If your lordship holds him to be invalid, 189 comes only after your lordship holds something to be invalid. Otherwise, it doesn't come into play.
It is said in the context of the vote in the House.
So,
With respect to.
exactly. So, therefore, no. 189, your lordships can and may, and in this case, perhaps should, in the intervening period of 7-8 months, the decisions taken by an otherwise illegally constituted government may be valid under 189. That's the real commonsensical way of implementing it, Balas. I am not suggesting that somebody's appointment is quashed, somebody's transfer is gone, somebody's policy decision.
So what you're really saying is,
liquor policy,
Dr.
therefore
Singhvi,
that is
what you're
gone.
saying is that Article 189 recognizes a de facto doctrine.
De facto doctrine.
What the de facto doctrine does is to legitimize the acts of an authority whose original appointment is found to be invalid.
Subsequently found to be
invalid.
Correct.
But that does not validate the original appointment
That's
itself.
that's the one sentence pithy summary. Just give me a minute. Come to D, 8D. 8D. Or calling for that goes back to the same thing, Wallace. First act was what? The governor being approached, governor calling. The two others are consequences. Voting is a consequence of the governor's illegal act. So is the oath taking. If the original act is bad and your lordships can't validate it, then this will not validate the vote. Wallace. The consequence is bad. The consequence of an illegal origin cannot validate the illegal origin. And similarly, 189 cannot.
What you're saying is that if the calling of the voting in the House itself is subject
That's
to.
just how my lords formulated was right or wrong. Governor's action, A, no basis, and B, if basis, well, it is wrongly applied, etc.
But that's affirmation of the House, right? Then what? I mean, I still have it.
Affirmation is coming. That's this section. Bombay dealt with the affirmation.
All right.
Bombay said, we hold something to be illegal. Let's kindly give me a minute. This is very interesting. But thereafter, Parliament has approved it. Exactly the same thing. How can we quash it? Said, no, sorry, you will be quashed. Can we come to that now? So, first, well, let's come to, yes, I'll just show 350. Just keep 356. Sima's query answered by Bombay. Para 4 of my note, this note. Much worse, fellas. Here there was nothing, in our case there was nothing. There was a presidential proclamation affirmed by Parliament. in Bombay. Now come to Malus para 4. It is respectfully submitted that the said contention is misconceived, liable to be rejected in Bombay. Does my lord have it, Malus? Para 4? Do my lords have it?
Yes.
Yes.
Consider the effect of approval of a presidential proclamation by both houses on the legal validity of the proclamation when it is questioned before the Constitutional Court held a clear majority, 5 judges, Malus, that if a proclamation on thrift is invalid, the same as liable to be set aside even if it has been subsequently approved by both houses. Your lordship is told 289, 189. This is express approval. This is express approval. Now read this para. Very interesting. 110 Justice Sawant for Justice Kuldeep Singh.
We'll set this up. We got the point. I mean, you're saying that the Bombay has a.
Now there is one interesting, very interesting. After 29 years and 2 days, this is happening in the lordship's court. This para 110, that bold face line by Justice Sawant says invalid. Lordship got the second line underlined.
Yes.
All the books say it's valid. SCC. SCR correctly says it's invalid. SCC for 29 years and 2 days called it valid.
I hope you're citing our ESCR, Dr. Singhvi.
No. This is, we've checked up. Then they issued a corrigendum. When my learned friend's colleague here, sitting here, pointed it out, then Malus, the SCC
Dr.
issued a
Singhvi,
corrigendum.
I must also publicly acknowledge there was a glitch in our ICT infrastructure overnight. My team was working till 5:30 in the morning. They began working yesterday.
Oh, I see.
They left for their homes at 5 o'clock in the morning, 5:30 in the morning, to ensure that we are all
It's very creditable.
we are ICT enabled.
It's very creditable.
And unlike the private sector, they wouldn't get even a rupee worth of bonus. It's just a love for the job that they do it.
The time money.
Private sector, the senior education.
Your lordship is entitled to judiciary. Right, Malus.
Batao. You are part of them.
Was.